Today, I am joined by Julian Cohen. He is the head of resolution chambers in Hong Kong. He is an internationally renowned lawyer and arbitrator in the construction field, ex-partner of major international law firm, good friend and good human. Julian, thank you so much for flying all the way to Bali to have a conversation with me today. We're very grateful that you're here.
Dan, it's a great pleasure. I always enjoy our conversations.
Me too. So for our viewers, for our listeners, please could you give a bit of an introduction in terms of your career in the legal industry and how technology has touched on the work that you do today?
Of course. I was called to the bar in England in 1990. I took a year out and went and worked in Paris for a French law firm. Got involved in the Channel Tunnel disputes. Then throughout my career, I've always enjoyed being an early adopter. And I'm already thoroughly enjoying using AI, although I do think we have to be incredibly careful about where that goes.
Absolutely. So in terms of mine and Julian's relationship and interactions over the last few years, Julian was one of the first barristers in Hong Kong that I spoke to about AI. And this was long before it was widely adopted. We had a very interesting conversation and have continued to do so. From that first conversation, every 3 months or so, me and Julian hop on a call to talk about the good, the bad, and the ugly when it comes to AI. So just to kind of bring everyone up to speed, how is AI presenting itself in your work at the moment?
I think there's probably two parts of that. How is it presenting itself and what bits am I not aware of? Because it may well be that quite a lot of people are using it without me having knowledge of that. In terms of my own use, primarily at the moment, legal research, not relying on it, but it's a good equivalent of maybe a good 1 to 2 year PQE lawyer that produces a product that you can look at and interrogate and make use of. But I don't rely on it. I rely on it as a starting point. Second is, to a certain extent, trying to produce summaries of things. Again, I find it's a good starting block. I had to analyze a settlement agreement, quite a difficult settlement agreement. I ran it through a legal AI platform, making sure it was maintained client confidentiality and privilege. And it came up with a very interesting analysis. It probably came up with 10 points, 5 of which were, yep, I agree with that. A couple were, I hadn't thought about that. That's a really important point. Let me think about it. And a couple which were, okay, I can probably discard those. It wasn't yet at the point where it was client specific. So you had to take it as a starting point and then think about how to adapt it. But in terms of getting me started and allowing me to spend more time doing higher value thinking as opposed to just the initial stage, which is relatively low value. It was excellent.
Amazing.
I come across it, unfortunately, a lot when people are applying for pupilages or positions in chambers, because people obviously sort of send me applications which have clearly been written through AI. That's a bad use. And there's no doubt that, particularly when I'm an arbitrator, people law firms are using it in the background in ways which I may not be aware of.
Yeah, okay. We had an interesting conversation prior to sitting here this morning around the effect of AI in the law. And I work on the vendor side, the implementation of programs consciously by lawyers to help with their work. And your question was, am I talking about that? Or are you talking about scenarios that have been created by AI outside of the law that the law now has to deal with? And I found that really interesting and the distinguishing facts between the two. So if you could touch on that a little bit in where you're seeing it on both fronts, I think it's a really interesting topic.
Well, I think where I'm trying to distinguish is between how lawyers or judges or people involved in the legal industry are adopting and using AI to help them do their work, on the one hand, and on the other hand, how the legal industry, particularly ultimately judges and arbitrators, are having to deal with the consequences of the adoption of legal AI. In the latter camp, we're familiar with the problem of hallucinated authorities, where a lawyer puts before a court or a tribunal an authority that they found using AI, but where the AI has hallucinated and created that authority, including quite often coming up with a plausible citation for that authority. And in that situation, the court or the tribunal, having identified that it is a hallucinated authority, has to deal with the consequences of it. And that leads to some interesting problems. I mean, firstly, you're starting to see concerns about how you actually report those hallucinated authorities in judgments. There was some guidance given by an English court relatively recently, last month or so, in which it was starting to encourage judges not to quote the hallucinated citation in their real world judgment when they're talking about the hallucination, because people were starting to realize that what happened was legal AI research would see the hallucinated citation in the real world judgment, but not necessarily appreciate it was hallucinated. And so the AI then picked that up as a real case, and the case cited in the judgment. And then it starts entering into the chain of authorities, and the fact it was hallucinated gets lost. So there's some issues around there.
So even the individual AI task that someone is running to do research might not have hallucinated, but because a previous engine had, in a different scenario, it had been brought into fact by the judge quoting that citation in the judgment. Interesting. It becomes a kind of feedback loop of misinformation.
Yeah, absolutely.
I
mean, and you've got that on the one hand. You've got, how do you make lawyers responsible for the use of AI? We might want to talk about that a bit later. But for example, at the moment, the courts, rightly in my view, are saying, if you use AI as a lawyer, you are responsible for its use and for checking it. So if you put before the court a hallucinated case, that's a disciplinary matter, and it's almost certainly negligent as well. And at the moment, that seems to me realistic. But the more that we get into agentic AI, where AI is going off and doing things in the background, unless you can interrogate it and find out exactly what it's been doing, how do you make a lawyer responsible? If I press a button and I don't know what the machine is doing, and there's no way of finding out, am I negligent by using the machine? Or or is someone else negligent, for example, whoever created the algorithm? Or is no one negligent? And if a client has genuinely suffered loss because of something that was negligent in the legal industry, and no one's responsible, then does that client have to bear the cost and the losses themselves, because they can no longer prove a case against the lawyer or the AI vendor or the coder? And that's going to have massive implications, I think, going forward.
And that's the kind of thing, although slightly different flavor, it's the kind of thing that's being kind of starting to be addressed in that kind of autonomous vehicle space, driverless vehicles, right? So you've got the car, it doesn't have a driver. The car was built by one person, the AI that's running the car was built by another, and then there's the owner of the car. And lawyers have to create now a framework for how we deal with scenarios like that, and that's translated into exactly the same. It's when a lawyer's using this kind of technology, who's responsible? The person providing the output, the person checking the technology, or the lawyer using that information?
At a legal level, if you have been rendered a paraplegic because of a car accident, if that car accident was caused by the negligence of a human driver, then you can get, assuming you can prove your case, you can get damages for the costs of all your care going forward as a paraplegic, loss of earnings, etc., from the driver or her or his insurance company. If all that happened was the driver was legally using a driverless car and there was no reason for the driver to intervene, then why is the driver liable for that? If the driver's not liable, is the vendor or the whoever is coming up with the algorithm or the program liable? And if no one is liable because perhaps the coder didn't do anything wrong, or the vendor didn't do anything wrong, or just came up with the appropriate warnings, then does that mean society will now find a different way of providing for the cost of care of the paraplegic? Or does it mean the paraplegic effectively, unless they happen to be wealthy, is condemned not only to having been permanently injured, but not having the financial resources to deal with that? So I think these questions are really important.
I think so too. And I think, like with that example, I find it such an interesting rabbit hole to go down, and we'll try not to go too deep.
Well,
but
we're going to go down rabbit holes.
we'll try. In that scenario, it's the way that the law is built at the moment. The framework of the law is to evaluate that from an individual scenario. What happened? What were the events leading up to it? Who was responsible in that moment? But if you take a real step back and look at the progression that AI can make in that space, for example, if it was proven that road traffic accidents would decrease by 30% if all cars were driverless, but you might have a risk of not knowing who to pin it on if there was an injury, do we as society sign up as a whole to that? And that maybe there's a £10 a month insurance that everyone now has to pay to live in a safer world? And it's like there's this constant balancing act in all these legal situations that I see where it's like the individual circumstance, that particular case study versus the overall innovation in that space and the safety of the entire framework. And it's almost got to be looked at with a micro lens focused on the individual case, but also the big picture of moving things forwards and innovating, and whether that's productive.
I think that's absolutely right. And it's going to be almost certainly throughout society. I mean, we've talked about law briefly, we've talked about cars briefly, but the same issue will be in the medical professions. AI may be extremely good and far better than humans at identifying and diagnosing things, but it will get it, almost certainly will get it wrong, potentially in ways which would be negligent if a human being did. You have the same issues as who's going to be responsible or liable. I mean, particularly as AI becomes more sophisticated and the end user, the doctor, is less able to work out exactly what the AI is doing. Again, if you suffer life-changing injuries because of what would have been medical negligence, is society going to pick up the tab for that? Are you going to see the sorts of changes you've talked about, maybe insurance funds making society more responsible rather than the individuals? And that raises some interesting questions about whether big tech should make lots of money while society picks up the downside, or how does big tech fund it? But I think there's going to be, if we go, the more we go down agentic AI with AI doing things in the background, and particularly if we get to the point where the original programmers don't know what the AI is actually doing, the more those issues are going to come up, but we probably need to get ahead of them now.
Yeah. In terms of your role in the legal world, you wear a number of hats. You lecture, you're a head of chambers, you're a lawyer, an arbitrator. How do you see AI showing up differently with your different hats on?
I mean, I think we're moving from sort of part two, which was how does the law deal with the consequences, into part one, which is how do people in law use AI? I would draw a distinction, for example, in my work between my work as a lawyer or a barrister representing a party on the one hand, and as an arbitrator on the other hand. And I would subdivide the role of the arbitrator depending on whether I'm sitting in Hong Kong or Singapore, for example, common law jurisdictions, and whether I'm sitting in, say, Dubai or Indonesia, civilian systems. And perhaps we start with that and then move back to my role as a lawyer.
Yeah, absolutely. Okay.
There's a huge difference between the way in which common law countries and civilians use and look at arbitration.
Yeah.
This probably won't reassure people, but my job, if I'm a common law arbitrator, so I'm sitting, say, in Hong Kong or England or Singapore or Australia or New Zealand, is not to get the right answer. That's not my job. I don't mean my job is to get the wrong answer. You'll be glad to know. But my job is to get the right answer based upon the way the parties have presented their case to me.
Got you.
I can't stray outside the bounds of what they have presented to me.
Okay.
Save in very exceptional circumstances. And probably more specifically, more accurately, my job is as a referee to evaluate, based on how the parties have presented their case, whether the party with the burden of proof, usually the claimant, has met that burden, has persuaded me at least 51-49, or has not met that burden and therefore has won or lost. But my job is very much driven by how the parties present their case. And if I, as an arbitrator, go outside that, I risk the award being invalidated or set aside because I have entered into the arena. I've started getting involved. And there are two potential downfalls there. One is that I've started to get involved and therefore I'm potentially not impartial. And the second is, if I haven't invited the parties to address me, they haven't had an opportunity to argue their case anyway. But even if I've asked them to address me, I have to be careful. Now, that becomes really interesting when you start applying AI to it.
Yeah.
Because let's just say that I'm doing a construction case about delay. I take the core bundle, not every document in the case, but the core bundle, maybe equivalent to 15, 20 lever arch files, put it into AI and ask it to produce a chronology. There's a pretty good chance, I'd say probably a racing certainty, that it will come up with events that the parties haven't argued about or raised that will enter into the chronology. Now, if I do that and rely on it, I'm starting to get into problems.
Yeah, okay.
Because suddenly I'm starting to be investigating and not deciding the case on the basis that's been put to me. And that could well lead to the arbitration award being invalidated unless the courts suddenly take a different approach to that using AI.
So your job is not to look at the entirety of the facts and come up with a decision. Your job in that scenario is to look at how each party has presented the facts, and more importantly, the person who has the burden of proof has presented them in a way to help you reach a decision. Not that you've looked at everything, made your own mind up, and proceeded.
Absolutely.
Yeah.
Which is very different if you move over to the civilians world, where, as a generality, if you're sitting in Dubai or Indonesia or France, other civilian countries, the job of the arbitrator is to be the investigator. It is to be inquisitorial. It is to try and work out what the right answer is. So if AI starts being adopted by arbitrators without thinking about it in common law countries, it seems to me that there's two possibilities: either increasing numbers of awards being set aside because they shouldn't have done that, which is what I would expect to happen, because I would expect the courts may well just apply the same test that they would apply to human decision-making in the realm of AI decisions or AI-informed decisions. Or alternatively, maybe the courts take a more relaxed view, in which case questioned as common law type procedure start harmonizing more towards the civilian. But clearly that, in my view, is a debate that needs to happen now. I mean, I have thoughts about what answer I'd prefer, but that's not really the point. For me, the point is we ought to be saying what is the legitimate role and use of AI by a tribunal.
And obviously one of the perks of AI is that it can analyze and condense huge amounts of information. So it can look at that entire data set and not necessarily take into account the way that it was presented. The question for people building and wielding this AI is, will there be different versions of it for civil law versus common law? So will there be AI that is educated to understand that they're only allowed to use facts when they fit into this box versus everything that's available at that disposal? And that's going to be an interesting one. And that's why I always talk about you need all of these conversations happening up front with the right people that are viewing it through their lens. You as an individual have different viewpoints because you wear different hats for different parts of your role. And that's happening on scale 1000x that across the industry. So it's exactly right. These conversations just need to be happening. And it's how do we govern it and how do we harness these tools to provide the outcome that's right.
I mean, another easy example, apologies for always resorting to arbitration, but you can have a human tribunal secretary who's allowed to get involved with helping project manage the arbitration, finding documents, writing the procedural history of the arbitration, but they're not permitted to start getting involved in the decision making or the determinations of the actual case itself. And if they do, then the award is susceptible to being set aside. In generally in both common and civilian systems, although there are some exceptions around the world. There's an odd German case, for example. But a human tribunal secretary can't get involved in the decision making, which almost certainly extends to can't go in the common law, can't go away digging for evidence that the parties haven't put before the tribunal.
Okay.
Now, I take a fairly simple view, which is why should I be able to delegate to a machine something that I couldn't delegate to a human tribunal secretary? In other words, how can I delegate to a machine something that a tribunal secretary is not permitted to do? Again, I have views, but for me, the question is, the important thing is not my answer, but that we should be having these discussions now and getting ahead of it rather than finding that it's all rather too late.
With your hat as a head of chambers, what advice do you give to colleagues and people that look up to you when they're entering the realm of AI and beginning to use it in their work?
I think we were probably the only, but certainly one of the only chambers in Hong Kong to have an official AI policy, which is up on our website.
Oh, wow. Okay. Yeah.
That is really at the moment, I mean, I've largely taken it from judicial guidance and guidance from different bars and law societies around the world. And particularly England and Australia tend to be quite far ahead in terms of thinking about these sorts of things. A lot of the emphasis is just avoiding some serious but fairly easy problems to get into. If you put legally sensitive or client confidential material into ChatGPT, one, you have almost certainly breached your obligations of client confidentiality because it's not confidential. So that's a disciplinary offence. And also in common law countries, you may well have waived privilege because you've published it to a third party. So a lot of the guidance is at the moment is be careful about doing that. You have to choose the right platform. You have to consider client confidentiality. You have to consider questions of privilege. The next chunk is you are responsible for the output. You can't just rely on it. And the third is encouraging people to think carefully about why they're using AI and what they're using it for before they press the button. Not to deter them, but to try and encourage a degree of responsible use.
Yeah. I always say to people, I do a lot of training on adoption of AI. And I always say to people, never use it in anger for the first time you're doing something. Never use it to build, let's take a simple example like a chronology. Never get it to build your first chronology when you're under a deadline. Use it when you've got a bit of space and a bit of time to use it almost playfully, curiously, so that you can sit there and go, okay, I see what's happening. Looks great. It's doing it quickly. What's actually happening?
I think it's a really important point. One, because almost certainly there are a lot of people like me who start using it in anger because and I phoned you up saying, help, I'm on a deadline.
Oh, yeah.
I don't know how I'm going to do this in the human way. How do I use a particular AI platform to help me?
Yeah.
And lawyers will do it like that. And secondly, it's something that I've seen quite a lot as a problem over the years, which is that's exactly what happens. There are, for example, some very good electronic evidence presentation platforms out there, which are extremely useful during hearings. You can do all sorts of coding and issue analysis and things on, but they get adopted just at the point that you're going into the hearing. And the vendor shows you all these great things, and you think that's really great. That's been really useful.
Yeah.
But you never get around to actually learning to do it properly.
Yeah.
So when it comes to the hearing, you actually only really use it to look at the screen or to occasionally find a reference.
Yeah.
And you're not using the technology. So in terms of procuring technology, you're absolutely right.
Yeah.
But how you get lawyers to actually do it playfully.
Yeah.
And not wait until the deadline. I'm not the best person because I fall into that trap.
Yeah, it's really interesting. I'm going to ask you two final questions as we round up this conversation. I'm going to ask these two questions to everyone that comes on this podcast. And my full expectation is I'm going to get a whole range of answers, and it's going to prove the point that we need to listen to all parts of the industry. So you'll have an interesting one because you wear a multitude of hats. But one of the questions I'm going to ask, and this could be, think of this as broadly or as focused as you like. What's one of the kind of most creative or most exciting or best uses of AI that you've seen to date?
The most creative happened to be when you asked this question in a conference that we both presented at in Singapore last year.
Oh yeah. Okay.
When you asked exactly that question, and someone who won the prize by putting into legal AI, what is the best, almost creative way that I can use AI? I can't remember what they answered.
Yeah.
But using, it did strike me that using AI to answer what's the best use of creative use was quite entertaining.
And I begrudgingly handed over the prize that was AirPods in that scenario, feeling beaten by the practice that I preach. Yeah. Yeah, okay.
But at a more serious level, probably at the moment, for me, it's legal research.
Yeah, okay.
Because I've actually found that I've gone back to reading more cases more deeply and thinking about stuff because the basic labor of trying to find the starting point or trying to find the best way in is made easier. So it doesn't save me time.
Yeah.
But I spend much more time thinking about things and actually doing work that benefits the client.
I actually nick one of your quotes quite often when I'm speaking with clients, and it was, AI doesn't save me time. AI just allows me to turn up to my trials, meetings, and parts of my job better prepared because I've been able to think to a deeper degree. And it's that element. It's you get a certain amount of the way quite quickly, so you can spend more time doing that strategic thinking. And I think there's been a lot of fixation on AI saving time and speeding things up, and it's what are you doing with that time, which quite often defines whether or not you're wielding this technology powerfully or not.
I mean, I think there's a wider debate which is around efficiency. I mean, you get it again. Sorry, arbitration. Efficiency being about speed, whereas for me, efficiency is about applying the right amount of energy and effort and time to the problem. And that may be the fastest one, or it may be that you need a bit more time. But it's about efficiency, isn't about speed for me. It's about the investment of time, energy, work
Yeah.
for the outcome and the appropriate one.
So wonderfully put, and actually probably answers the second question, which is, where do you think we should be focusing more of our thinking and energy when it comes to the future of AI and the law?
I think the big issues are going to be need to be around, one, how do we make efficient use of it without losing the importance of the legal system and confidence in it? Maybe not an issue with specific tailored legal platforms, but for example, if you start using legal AI with a data set that has racial bias in it or gender bias in it, so that actually it worsens the problems of bias, that's going to be a serious concern. You've got a question of, do we know what AI is actually doing? The more it gets involved and the more agentic it comes, do you end up in a situation where AI is taking over, but no one really knows what it's doing, so it's not transparent? And I mean, you made an interesting point when we were discussing things before, which is the more that AI becomes agentic and the more it gets involved with doing things, the more the vendors and the platforms need to make sure that it's also capable of explaining how it's doing it and why it's doing it and what it's doing. So there needs to be a sort of ratcheting up between use and transparency within the AI, but making sure that that happens. And then I suppose at one level, there's a legal maxim. Justice not only needs to be done, but needs to be seen to be done. And again, at a macro level, society level, are we, human judges get it wrong. Hopefully not very often, but they get it wrong, or the law develops. But you can interrogate them and find out their thinking process. I mean, not literally interrogate, but the courts, the superior courts can look at it and evaluate it. But the more that it goes into a black box in AI, even if it's giving a better result or a more reliable result, even if that's the case, does it matter that people can't see how it's being done? And you only need to look at the number of people that turn up to big, important trials to realize, I mean, partly it's entertainment, but actually people do want justice to be seen to be done. And are we willing to sacrifice that for the benefits of AI? Or do we try and harness AI in which justice is done, but also continues to be seen to be done by involving human beings? And something I know that's dear to your heart, which is the more that we involve AI, I think the answer is the more that people need to get together. And it still needs to be a human process, adopting AI as a tool. But the conversations around that need to take place, I think, now, because in 5 or 10 years' time, the genie may be out of the bottle, and it may be difficult to put the genie back and put guardrails up.
Yeah, I completely agree. Thank you, Julian. I deeply appreciate your thoughts and conversation as always, but also going out of your way to fly from Hong Kong to Bali on your way to Dubai to see me.
Well, my geography was never very good.
Not good for efficiency over that, but no, really appreciate it. And let's see what the others have to say with a different lens.
I look forward to watching the rest of the series.
Awesome. Thanks, Julian.
Thank you.